Hey guys, just wanted to quickly walk you through Planned Parenthood versus Casey. This one's a lot quicker than Roe and a lot simpler to get through, although it's a little tough to tell who's writing it. The judges were pretty grouchy about this one and didn't really agree, so you'll notice that different people wrote different sections of the case. It's just because they couldn't all agree what to write. So beginning with Planned Parenthood versus Casey, it was a Pennsylvania statute that had a couple of different provisions, and a bunch of different people sued to have those provisions ruled unconstitutional. Let's go through and look at what they were. First, there was an informed consent requirement. There was certain information that you had to give the woman, the nature of the procedure, the time frame, the gestational age of the baby, that the physicians were giving the women, and then requiring them to wait 24 hours after they had been given that information before obtaining the abortion. The second was that a minor seeking an abortion needed to have consent of one parent, but there was a judicial bypass for that, meaning that if that was going to be a dangerous situation or it was going to go bad or they didn't have the parent or whatever, they could go before a judge and bypass that requirement to obtain the abortion. And the third was that the woman's husband, she had to sign an affidavit indicating that she had notified her husband that she was going to obtain an abortion. So those were the three things that were up for discussion here. The court first goes off to just discuss that whatever they do here, they're going to reaffirm Roe. And there's three things that they specifically want to reaffirm. The first, they recognize a woman's right to choose to have an abortion before fetal viability and to obtain it without undue interference from the state. This is before viability. Second, confirmation of the state's power to restrict abortions after viability if the law contains exceptions for the woman's life and health. And then third, the state has a legitimate interest from the outset of pregnancy in protecting the health of the woman and the life of the fetus that may become a child. So you'll notice that language is a little different, where the state has an interest in protecting the life of the child from the outset of pregnancy. So that language is definitely different from the language that we saw in Roe. And then they continue to discuss for a pretty long time why they want to reaffirm Roe and not overrule it, even though you'll see that they're going to do something pretty different. They indicate that because Roe is the precedent case, stare decisis, which just means we're going to follow what's already come before us, requires that Roe be reaffirmed, and that even though it's unpopular with some people and it's had some controversies, it's not unworkable. They talk about the merits of Roe for another page and some. They do reject the trimester framework in Roe and instead impose an undue burden test, and you'll see that language on what for my printed case is page 3 under A, and I'll read that. An undue burden standard should be employed. An undue burden exists, and therefore a provision of the law is invalid if its purpose or effect is to place a substantial obstacle in the path of a woman seeking an abortion before the fetus attains viability. So the undue burden standard is only appropriate before viability, and if the regulation is attempting to place an undue burden on the woman, then it's going to be unconstitutional. Or if it's not attempting to do that, but it unnecessarily does place an undue burden on the woman in attempting to seek an abortion, then those are going to be unconstitutional provisions of a law. So, looking a little bit further down the page, you'll see where the court begins to discuss the notification of the husband. That's the first thing they get to. They quickly come to the conclusion that that does present an undue burden and is invalid. They indicate that a significant number of women will likely be prevented from obtaining an abortion, just as if they'd outlawed abortion altogether. One of the reasons that they give is because they indicate that it cannot be claimed that the father's interest in the fetus's welfare is equal to the mother's protected liberty, since it's an inescapable biological fact that the state regulation with respect to the fetus will have a greater impact on the pregnant woman's bodily integrity than it will on the husband's. So that's their primary reason, is it just, their argument is that women have more skin in the game in this, and so they shouldn't have to obtain consent from their husband in order to obtain the abortion. Moving on, they talk about the informed consent provision and the 24-hour waiting period. They say here that giving of truthful, non-misleading information about the nature of the abortion procedure, the attendant health risks, and those of childbirth, the probable gestational age of the fetus, and all of those things are perfectly appropriate for information for a woman to receive. Further along, they say there's no evidence here that requiring a doctor to give the required information would amount to a substantial obstacle to a woman seeking an abortion. And so they find that that is appropriate and is not unconstitutional. The third section that they get to is the provision that discussed whether a minor needed to obtain consent from their parent. They say the one-parent consent requirement and judicial bypass procedure are constitutional. And I think the reason that if there had not been the judicial bypass, a way to get around it if there was a dangerous situation or something else, they might have gone a different way on that. But because there was a judicial bypass, that was appropriate and not an unconstitutional provision that would provide an undue burden to a minor seeking to obtain an abortion. So that one's pretty quick. Gets through it pretty quickly. You'll notice if you're interested, if you look down at the bottom of that page where you see the Chief Justice joined by Justice White, Scalia, and Thomas. Scalia does not care for any of the cases that provide abortion rights. But you'll see down, they don't like the undue burden standard at all. And I've always said that this argument does hold weight and it kind of would be difficult. They say to evaluate abortion regulations under that standard, judges will have to make the subjective, unguided determination whether the regulation places substantial obstacles in the path of a woman seeking an abortion, undoubtedly engendering a variety of conflicting views. So what they're saying here is the undue burden standard is just going to be really subjective. And what one judge determines is an undue burden in one part of the country, another judge may determine is not an undue burden in another part of the country, just depending on who the judge is and their political views and their feelings on the subject. It's such a subjective standard that it might be tough to be as workable, whereas the trimester framework in Roe was pretty rigid. First trimester, second trimester, third trimester, certain rules. So those are some of the takeaways from Planned Parenthood v. Casey. Stay tuned for a discussion of Carhartt.